coming up.
The House order actually supersedes and goes beyond any type of restrictions that an ATIP law may put into place.
Yeah. As you summarize it the power of the House to compel the production of documents is a constitutional power.
What we have is a Minister of Industry who claims that he is interested in getting to the bottom of corruption at SDTC. And yet, contrary to what the Minister has asserted, Minister Champagne, what you have confirmed, Mr. Bedard, is that he has invoked cabinet confidence to protect himself surrounding issues of corruption at SDTC.
What about cabinet confidences? At times, they're being redacted as well. How do you feel about that? Are there any rules being broken there? Can you explain that process of?
In terms of...
Just in generalities,
yes.
Just in general, yeah.
Okay.
This Guy's Garage. Like and subscribe.
A question of privilege has been raised in the House of Commons on September 16 regarding the compliance with the order. On September 26, the Speaker ruled that the matter constituted a prima facie case of privilege. The House Leader of the official opposition, Mr. Scheer, then moved that the matter be referred to the Standing Committee on Procedure and House Affairs. This motion is still being debated in the House of Commons. This concludes my remarks. I will be pleased to answer your questions to the extent I can under the order of June 10, and taking into consideration that the House is still currently debating this matter as a question of privilege, and whether the Standing Committee on Procedure and House Affairs should be seized of the matter.
Before I get into my line of questions, I want to step back a little bit and begin by noting that what I'm about to ask actually has no bearing on our ability to request documents, but I think to put some people's minds at ease, could you indicate to the committee what steps you have taken in your office to respond to concerns about documents being left in being provided to you in terms of security clearances of yourself and anyone else who may be in your office?
Excuse me, there was some noise, so I could not understand correctly the question.
Yeah, absolutely. Basically, what steps have you taken in your office to protect the documents that may be provided to you, including security clearances for yourself or members of your team?
Well, first of all, the documents were produced and deposited with me as under the authority of a production order that was adopted by the House. And this constitutes the exercise of a parliamentary privilege to compel the production of documents. And this is a parliamentary privilege which, as all the other privileges, is constitutional in nature. And that has been recognized as such by the courts. Now, our role under the order was very limited to receiving the documents and providing them to the RCMP. We made sure that we were limiting the circulation of documents. So only 2 persons in my office with top secret clearance had access to documents, myself and another counsel. That said, as they were obtained through a production order, the top clearance requirement was not a requirement per se, but we nonetheless took that step.
No, I appreciate that, and I appreciate the clarity, too, that it isn't relevant, but it is nonetheless an extra step that you have taken in your office. I want to begin now with this morning's tabling of the recent update. Included in that report this morning was the comment that redactions were made pursuant to the Access to Information Act. Could you confirm with this committee that those redactions made pursuant to the ATIP are actually not permitted under the House order, that the House order actually supersedes and goes beyond any type of restrictions that an ATIP law may put into place?
Yeah. As you summarize it the power of the House to compel the production of documents is a constitutional power that is a parliamentary privilege. It supersedes over ordinary law. So it will prevail over the Access to Information Act, the Privacy Act, and, for example, solicitor-client privilege.
So the fact, I mean, and I don't want you to, or don't want to put you in a position where you're going beyond the focus of this meeting, but it is clear that the Speaker of the House of Commons has found a prima facie question of privilege on this matter because of the failure to produce certain documents, the failure to produce unredacted documents, and to see an excuse being used that is clearly not relevant to the documents at hand, to the House order, is actually quite concerning from the standpoint of this committee and from the standpoint of Parliament as a whole. There's a phrase that's often used that Parliament is the grand inquest of the nation, and part of that importance is that we are able to compel the production of papers, the production of documents, and the requirement of witnesses to appear before this House. So from a constitutional standpoint, from a standpoint of the grand inquest of the nation, can you explain to this House why it's important those privileges, those important rights of Parliament be maintained for us to fulfill our duties as parliamentarians?
It goes to the very raison d'être, or reason for parliamentary privilege, that the House of Commons, Parliament in general, have the autonomy it requires to perform its functions, to hold the government accountable, to legislate, to deliberate. So that's the root for all parliamentary privilege. And as part of its function to investigate and hold the government accountable, if a committee or the House require documents, it can order the production of these documents.
And can you confirm that applies whether it's a committee has the same power to compel the production of documents as the House of Commons itself?
The privilege belongs to the House of Commons. It's delegated through the standing orders to committee. If there is a breach of this privilege, committees cannot themselves impose sanctions. They have to report the matter to the House.
We're still there with committees to do that, but we would have to go through the House to impose sanctions. Going down that route, what are the available sanctions that are available to committees or to the House as a whole, or for committees to recommend to the House as a whole for the sanctions to hold those who may not be complying with production orders accountable for their failure to do so?
There are various sanctions available. If we referring to some recent examples, we've seen recently a witness at the bar of the House being admonished by the Speaker. That's one sanction. In 2011, for example, another sanction was that the House of Commons remove its confidence in the government because they had not provided all the documents. So those are two examples of sanctions that are at each extreme of the spectrum.
Thank you very much. Moving to our next member, Mr. Erskine Smith, you have the floor.
We have a situation where the former law clerk, Rob Walsh, has called this an abuse of the House's powers. And then he says it's an abuse because the purpose of the House's powers is to enable the House to carry on its proceedings. How do you respond to that? What do you make of that?
As I indicated in an answer to a previous question, the root of and the reason for parliamentary privilege is to allow Parliament, the House of Commons, committees to perform their functions, deliberative, investigation, legislating, without any interference from outside, be it the executive or the judiciary. The order of June 10 has two components. First, there is the component that documents have to be provided to me as law clerk, and then the second component is that they be made available to the RCMP. It doesn't go further than that. If you look at the order, that's the only thing that there is in the order. Now, what the RCMP could do with the documents potentially could.
But pause that. I want to get to there. I actually just want to deal with the powers of the House, because you've got a law clerk, Rob Walsh, saying it's an abuse. And he says because the purpose of the House's powers is to enable the House to carry on its proceedings. And he's saying that the active intent to request documents for the sole purpose of turning those documents over to a third party is inconsistent with the power of the House, because the power of the House is to enable the House to carry on its own proceedings, not to simply pass that work on to a third party. What do you make of that?
Okay. As I indicated in my remarks at the beginning of my testimony, I need to be mindful that there is a question privilege right now before the House of Commons that has been debated for 2 weeks, and that the matter could be referred to the Standing Committee on Procedure and House Affairs as a question privilege. Now, in the assessment of the question of privilege, if the matter is ever referred to the committee, it could look at the fact that the order is indeed unprecedented and unusual. Now, if you look at the order, because there has been many things said about this order, but one needs to look at the text of the order and the paragraph of the order. It does not require the RCMP to do anything with the documents. It's
but it doesn't need to. And I want to get to what the RCMP could and should and could do, not even should do, could do, because how would these documents be able to be used in any investigation? You've got the RCMP commissioner saying the RCMP's ability to receive and use information obtained through this production order and under the compulsory powers afforded by the Auditor General Act and in the course of a criminal investigation could give rise to concerns under the Canadian Charter of Rights and Freedoms. It is therefore highly unlikely that any information obtained by the RCMP under the motion where privacy interests exist could be used to support a criminal prosecution or further criminal investigation. So if I'm defense counsel and there's been no search warrant approved on reasonable grounds here, my client's charter rights will have been circumvented, no?
I think that even before getting to the protection under the charter rights, one needs to look at the issue as a question of parliamentary law and whether these documents would be admissible in a court of law as documents that have been obtained under the authority of a House order that are directly and closely connected to parliamentary proceedings. Also, Parliament needs to, and the House and committees need to consider the potential impact of such an order. Witnesses come to committees and testify, and they're told that they have immunity while testifying. It will destroy the root of the privilege itself if testimony of documents produced were, as a matter of principle, referred to the RCMP once the evidence has been given. That will
I understand that. I understand that, but let's deal with the charter question as well, because in what world, you're a lawyer, in what world could this evidence be admissible, given it was not subject to search warrant on reasonable grounds? In what world? My former colleagues at the Canadian Civil Liberties Association are going to point a laugh at this. In what world could this ever be used? Because it's a clear violation of one's charter rights.
Yeah. As I indicated at the beginning, my role under the order was not to proceed to analysis of the document or an evaluation of the documents. I had to receive the documents and make them available to the RCMP. In doing this, and I also had to report to the House whether or not the order had been complied with. So I did look at the documents to assess whether or not there was any redactions. I did not read the documents, just had to look, just make sure that I could inform the speaker whether redactions had been made or not. In conducting this role, I was able to see that some documents were documents that would have been publicly available. Other documents are, in my opinion, would not necessarily raise a charter issues. That said, there is indeed, and I think that the RCMP and the Auditor General has expressed concerns, and other lawyers, and I concur with these concerns, that there might be potentially charter issues because there might be expectation of privacy in certain documents, and they have been obtained without any search warrant or production order. That said, before we get to the charter rights, Parliament needs to look at this order and its compliance or its rights under the parliamentary law to obtain documents.
Voilà. Merci beaucoup.
Thank you very much, Mr. Chair. Thank you, Mr. Bedard, for confirming that SDTC continues to withhold documents as well as having submitted documents that they have redacted. Therefore, SDTC continues not to be in compliance with the order of the House. There are other government entities that have not followed the order of the House, including the Justice Department. As of the summer, 11,517 pages of documents concerning SDTC have been withheld by the Department of Justice. Is that the case today?
I haven't received further documents from the Justice Department that they had not provided earlier because they had been redacted or withheld.
So, okay, thank you for that. That's a lot of documents that have been withheld by the Department of Justice. What about ISET? Are there documents that are outstanding from ISET or the Department of Industry?
I still have to receive documents from ISET, indeed. Yes.
And do you have any idea how many documents you're awaiting from the Department of Industry?
Excuse me, can you repeat the question? I misheard.
Approximately how many documents are missing?
Until I receive the documents, I have no idea as to...
Fair enough. Now, documents that the Department of Industry has submitted have been redacted, some of those documents. Is that correct?
Correct.
And others have been withheld?
There have been government entities that have provided documents with redactions or that they have withheld, yes.
And that includes the Department of Industry, on the point of withholding documents.
In relation to each department, I will rather prefer...
Okay. And the basis upon which the Department of Industry is withholding or rather redacting documents is on the basis of the Privacy Act?
I will have to check for a specific case. It's all in my reports. And it's either the grounds for redactions or for having withheld documents. It's always Access to Information Act, Privacy Act, solicitor-client privilege.
And you have confirmed that the House order supersedes all of those bases, correct?
That's correct. And the House order, contrary to some orders in the past, does not contemplate any redactions to be made to the documents.
And what about cabinet confidence? Has that been asserted at any point?
Yes, that has been asserted, and that's also a ground in the Access to Information Act.
Okay.
So when I refer to the Access to Information Act, that also included cabinet confidences.
And so would it be accurate to say that the Department of Industry has asserted it on the basis of cabinet confidence the minister has?
Again, I'm reluctant to comment on any specific department in particular, but generally, yes.
Okay, thank you for that. And would it be fair to say that ministers of the Crown are ultimately accountable to Parliament with regards to compliance by their department with respect to any order of the House?
Yes.
Yeah, well, I think, thank you for that, Mr. Bedard, because what we have is a Minister of Industry who claims that he is interested in getting to the bottom of corruption at SDTC. And yet, contrary to what the minister has asserted, Minister Champagne, what you have confirmed, Mr. Bedard, is that he has invoked cabinet confidence to protect himself surrounding issues of corruption at SDTC and is running interference, blocking the production of documents and obstructing a parliamentary order, an order that is specifically designed to get to the bottom of corruption at SDTC. The minister is doing exactly the opposite of what he asserted. It begs the question, what is he hiding? Thank you, Mr. Chair.
Thank you very much. Up next is Ms. Khalid. You have the floor for 5 minutes, please.
Thank you very much, Chair, and thank you, Monsieur Bedard, for being here today. I really appreciate the soliloquy of my colleague there, none of which is true, but I do have some quotes from people that I just want to run by you. Senior Parliamentary Counsel to the House of Commons, Monsieur Stephen Chaplin, stated that the June 10th order was both completely unprecedented and a likely abuse of parliamentary powers. He said that the House of Commons was simply acting as a mailbox for the police force, which is not one of its duties. He also stated that it is not a parliamentary or constitutional function of Parliament to help the police. In the same vein, former RCMP Deputy Commissioner Pierre-Yves Bourgeois also commented that we all know that the rule of law is predicated upon a separation between what Parliament is doing and the law enforcement agencies, in this case, the RCMP. Would you agree with those statements?
Under the, I mentioned earlier parliamentary privilege, and the reason for parliamentary privilege is to allow the House and its
Perhaps let me
committees
rephrase that a little bit. Do you share the same sentiments that are being conveyed by these two very senior people within our institutions?
I could answer the question to the best I can, because you refer to documents that express opinions, and I can offer my opinions to the committee if it's the will of the member, respecting the issues you have raised. Okay. The parliamentary privilege, be it the power to send for records and papers, to compel production of documents, the power to send for witnesses, exists to support the function of the House as the grand inquest of the nation, and the investigation power function of the House of Commons and its committees. Other parliamentary privilege exists so to protect the House and its members from outside interference. And parliamentary privilege does not indeed exist so that the House can assist outside powers, be it the judiciary or police forces, to conduct their functions. And as I stated, as a matter of parliamentary law, when witnesses testify before a committee or when documents are produced, be it submissions or documents, there are immunity protecting the witnesses, and these proceedings will not be admissible before a court of law. Traditionally, there's always a separation between various powers in Canada, and I think that this very committee has set the golden standard about 20 years ago when during the sponsorship scandal, there were one witness that was called upon to testify before the committee, while there was also a police investigation of the same person. And the committee, so to not interfere with the police investigation, decided to have the meeting in camera for the very reason not to interfere with the police interference, and kept those proceedings in camera for a number of years so that not to interfere with the investigation.
And thank you for that. Now, I believe it was Mr. Chaplin who also said that he believed that the House had overstepped here and that it raised a number of constitutional issues. And I know that you spoke about this a little bit earlier, but I would like you to talk a little bit more about what are the constitutional implications of this unprecedented move that has happened by the opposition in Parliament.
Without suggesting that I agree with the comment or the blog that you have just referred to, I alluded earlier to certain issues that had been raised. There has been charter issues that have been raised by the RCMP as well as the Auditor General. I earlier during this testimony raised that as a matter of parliamentary law, it's doubtful that these documents could be used as evidence before courts of law.
And, we've seen a lot of influence with misinformation, disinformation, and its impact on our democratic institutions. How do you think this kind of a political move impacts our core democratic institutions and the separation and the rule of law in how we conduct ourselves and maintain free and fair democracy here in Canada?
I won't answer to the general question because it invites House officer and we're impartial, nonpartisan, non-political. But I mentioned earlier that the parliamentary privilege are members, and they belong to the House, committees, and all members. So it's for the members to assess how they want to exercise those privileges. They're currently question privilege being debated before the House of Commons, and the motion is to refer the matter to the Standing Committee on Procedure and House Affairs, and that will provide the appropriate forum to discuss those issues.
Turn now to Mr. Stewart. You have the floor for 5 minutes, please, sir.
Thank you, Mr. Chair, and thank you, Mr. Bedard, for being here today. Finance, industry, and BDC are all sending in redacted documents. These are key departments up for public discussion here with certain hearings, many motions. These are departments that are being present at our standing committees on a very regular basis. Are they complying with the House order when they redact?
The June 10 order did not contemplate any redactions, and had the House wished for any redaction, it would have been stated so explicitly. And I think that was the substance of the Speaker's ruling, that the matter constituted a prima facie case of privilege. So yeah, the answer is no, that there was no compliance.
Okay. What about cabinet confidences? At times, they're being redacted as well. How do you feel about that? Are there any rules being broken there? Can you explain that process of?
In terms of
Just in generalities,
yes,
just in general, yeah.
okay. In terms of the power to order the production of documents, as I indicated, this power is absolute. Now, when a document is ordered, there might be legitimate privacy or other legitimate concerns not to provide the document in full. And if there are redactions, it's ready for the House or committees to decide on that. They accept the reason that were put forward not to see the information. And if the House or committees are still unhappy with the reason put forward, they can take further measures. It could be from ordering a representative to appear at the bar in the House, or as we've seen in 2011, withdrawing the confidence in government.
Sure. Thank you for that. As you know, Parliament is not bound by the Privacy Act, has a right to have any documents laid before it, which it believes are necessary. This power is absolute. As the Liberal chair of the committee, this very committee ruled in 2009. On the ArriveCan investigation, as an example, in an email discussing an OGO motion, the CBSA talks about redacting and withholding based upon, and I quote, spirit of the ATIP Act. Could you explain, is that allowed? Can you explain that process and how that would be allowed for them to redact and withhold based on spirit of the ATIP Act?
Well, generally, the power to send for records is unfettered. So if the committee requests unredacted documents, it is entitled to unredacted documents. And the Access to Information Act, Privacy Act, or any other act will not apply. Neither the spirit of the act. If redactions are proposed, it's up for each committee to decide whether or not they are accepting the redactions.
Okay. Is Parliament not supreme when ordering documents, or is CBSA allowed to deny the will of the committee?
The power to send for records and paper for Parliament is absolute. So yes, if the House or one of its committee is ordering the production of documents, it is entitled to it.
Okay, I appreciate that. I have no further questions. Mike, do you want to take the rest, or do we? Pretty much 5, is it, John?
All right, very good.
You've called this an unprecedented and unusual order today. That's right?
That's correct, and that's how the Speaker in his ruling qualified the order.
Okay, and now the Auditor General has said that there's nothing criminal here to warrant referring the matter to the RCMP. Just earlier today, before your testimony, the Ethics Commissioner said exactly the same thing. The Auditor General has expressed concerns with the order. The RCMP has expressed concerns with the order as well. You're aware of those concerns, yes?
Yes.
So now you've got the former law clerk, Rob Walsh, as well as former senior parliamentary counsel, Steve Chaplin. They've called the order an abuse or likely abuse of the House's powers. And you said here, and I just want to be clear in response to Ms. Calla's questions, you said that Parliament's function, the function for which its powers exist, is not to serve a third party's investigation. That's right? Okay, now you've also said that the gold standard to respect our separation of powers as a country was when this committee went in camera to avoid interfering with an RCMP investigation. That's right?
Could you repeat the question? I'm sorry.
You've said that the gold standard, you used the language of gold standard to respect the separation of powers, was when this committee, 20 years ago, went in camera to avoid interfering with a police investigation. That's right?
That's correct.
And here we are doing the exact opposite of that gold standard. And wait for it, because after all of that, the RCMP is unlikely to even be able to use the underlying information because absent a search warrant issued on reasonable grounds, the use of that information would obviously violate an accused's charter rights. So what precedent are we setting here? Where does this end?
I mean, in terms of the order, and in answering to Ms. Sinclair de Gagne's question, there might still be a use related to parliamentary proceedings with the documents that were produced, but that will require subsequent order from the House. If the intent is to have the documents used as part of an investigation of the RCMP or as part of as evidence before a court of law, it's at odds with parliamentary law.
Okay, well, let's imagine other scenarios, because once upon a time, you had a Harper government that was going after environmental charities. So let's say that Parliament, a majority-led Conservative Parliament, is so angry about that issue and so vindictive that they decide that they're going to order the disclosure of every single document email from an environmental charity. Parliament reigns supreme, right?
The parliamentary privilege to order the production of documents is an exercise of privilege, is absolute and unfettered. Yeah. Now, once absolute that has been exercised, the use of proceedings is by the parliamentary law subject to restrictions and limitations.
Understood. Absolute and unfettered. But absolute and unfettered, we ourselves should possibly subject ourselves to some reasonable framework with which we should operate under, because you could imagine a request for documents in any number of instances. You could imagine a number of unreasonable requests, including this one, where you are demanding such documentary disclosure in the face of the Auditor General's concerns, in the face of the RCMP's concerns, in the face of lawyers' concerns to say this is improper, in the face of former parliamentary counsel saying this is an abuse of power. We still have that power, and if we're willing to use it in this case, when are we not willing to use it? Anyway, thanks very much.